Good morning, everyone. Welcome to today's talk on limitation and the limitation periods for bringing claims under insurance contracts. It's 11 o'clock now, so we will proceed with today's session. Just a couple of housekeeping points before we start. The webinar will be recorded and all registrants will receive a link to the recording and a copy of the slides tomorrow afternoon. Participants will be muted during the session, but if you have any questions, there is a Q&A function which you can put your questions in, and I will endeavour to deal with them as we proceed or at the end. Or, of course, if you'd like to follow up privately, that's absolutely fine too. My details are on the slides. And finally, in terms of housekeeping, all attendees will receive a feedback survey. So please take a few moments to complete this. Your feedback's obviously very important to our continued programme improvements. So without further ado, what are we going to talk about today? So the starting point is that a claim by a policyholder on an insurance policy is a claim in contract, and as such, under English law, it's obviously English law that I'm talking about, the claim must be brought within 6 years of the date of accrual of the cause of action. And the date of accrual is the date the insurer is in breach of contract. So it will be necessary to examine the policy in every case in order to establish the point at which the insurer becomes obligated to indemnify. And as we're going through today's talk, looking at different policies, and when you get back to your desk to look at your sort of live claims, I'd ask you to always think about the point at which the insurer is in breach for failing to pay a claim based upon the wording of your specific policy. And we are focusing on the date of accrual, as that will be the point when the 6-year period commences, which in turn obviously dictates when the 6-year period expires. So unlike claims in tort, for example, or concurrent claims in contract and tort, where you might have 2 limitation periods running, or in tort where you have latent date of knowledge issues to consider, the claim under a policy is relatively straightforward in that once you've identified the start point of the 6-year period, the end naturally follows. So what else are we going to talk about? We're going to talk about these principles and how they apply to different types of policy. We're also going to talk about how limitation periods can be varied contractually, and also how an insurer can sometimes waive its rights to rely on a limitation defence. I was also going to talk about COVID claims with some thoughts around when these may first start to become time barred. And finally, I was going to finish with a slide on the Third Party Rights Against Insurers Act and the limitation, some limitation points that arise out of that. So the general position, and this will be, I hope, obvious to everyone really, but it's worth emphasising why limitation is so important. And that's obviously because a failure to bring a claim in accordance with the applicable limitation period can be fatal for the prospects of the policyholder's claim. Such a failure will not extinguish the policyholder's cause of action, but it will be a bar to a claim being brought if insurers elect to rely on a limitation defence. So insurers have to choose to rely on limitation. But from an insurer's point of view, they may have a complete defence to a claim which was otherwise covered by the policy. So because of the failure by the insured or sometimes by its advisors to prevent the claim from becoming time barred. So the insured, there may be a covered loss, none of the exclusions apply, the insured hasn't breached any claims conditions, etc. But a procedural failure can give the insured a complete get out of jail free card. And just going towards the end in terms of what you need to do to prevent a claim from becoming time barred, I think it's worth emphasising this up front. the insured will have to bring a claim within the applicable limitation period. And by bringing a claim for the purposes of limitation, the steps the insured will have to take are either issue a claim form, and that is if the policy is subject to the jurisdiction of the courts. So the claim form must be issued and then served, if it's civil procedure rules, within the 4-month period. So sorry, that's the claim must be issued within the applicable 6-year period. And note that issuing the claim form will involve a financial commitment on behalf of the insured in terms of paying the court fee, which could be £10,000. And the insured from that point onwards could in theory be on the hook for the insurer's costs if the claim fails. So issuing a claim form is not a step to be taken lightly and will generally be a last resort where it's not been possible to agree a standstill agreement with insurers. Conversely, if the policy is subject not to the jurisdiction of the courts, but to arbitration, then the insured will have to have commenced arbitration proceedings by the expiry of the limitation date. And when arbitration proceedings will be commenced will depend upon the arbitration rules or the arbitration agreement which the parties have selected. But there's a default position under the Arbitration Act which says that arbitration proceedings are commenced when a party serves notice requiring the appointment of an arbitrator. So it's either issue a claim form or issue an arbitration notice generally, or you can agree a standstill or agree a standstill with an insurer, which we'll talk about a little further on as well. The other point I'd like to make by way of sort of general introductory remark is that if you are an insured who has a claim on a policy, there's an awful lot to be said for progressing that claim as swiftly as possible, regardless of the limitation position and regardless of when the claim may become time barred. Evidence can go stale, witnesses move on, documents get lost, and there will nearly always be a financial benefit in having the claim determined sooner rather than later. So best practice will nearly always be to progress as quickly as possible and not wait as the limitation clock ticks down. Okay, so looking at some of the details, when does the cause of action accrue? As I've already mentioned, the date of accrual will be the date the insurer is in breach of contract for failing to indemnify the insured in respect of the loss suffered. And there is a consistent line of authority of case law for the proposition that the date on which the policyholder's action accrues will generally be the date on which the insured peril occurs, although it would be necessary to examine the policy in every case to determine when that point arises. So the relevant date is the date the insured peril occurs, and not generally the later date when, for example, the loss is manifested or crystallized, or the date when the policyholder incurs expenditure, or the date when the insurers deny liability. And this general principle is often explained on the basis that the insurer has agreed to hold the insured harmless against the occurrence of an insured event, so that when the event takes place, the insurers are in immediate and automatic breach of contract. So a few points arise out of that general principle. The limitation period is not, the start of the limitation period is not postponed by reason of the fact that the insured was at the time unaware of the occurrence of the insured peril. So, for example, in the case of a property policy, the limitation period generally runs from the date of damage and not the date of discovery, even though it is conceivable in some circumstances that the date of discovery may be sometime after the date of damage. Similarly, in the case of a fidelity policy, which protects the insured against fraud by an employee, the limitation period will run not from the date of discovery of the fraud, but from the date of the fraud itself. And as I say, the rule is that the insured's cause of action accrues on the date of the occurrence of the insured peril. And this principle applies to marine policies, to property policies, life policies, business interruption policies, and accident policies. There's a separate consideration in relation to liability policies, which we'll talk about in a second. But this is the essence of when the cause of action accrues. And the rule also applies to claims for mitigation costs, so that where an insured incurs mitigation costs pursuant to the policy, the cause of action will accrue at the date the mitigation costs are incurred. And there's a quote from the first instance decision in the Europools case on the slide, which explains why that is so. Namely, it seems to me, this is Mulder J, that the mitigation of loss clause is a first-party financial loss clause, and that the general principle applies, namely that the insurer has agreed to hold the assured harmless against a specified loss or expense, and once the loss is suffered or the expense incurred, the indemnifier is in breach of contract, having failed to hold the indemnified person harmless against the relevant loss or expense. Accordingly, the right to an indemnity and the cause of action arises immediately the expenses incurred to mitigate a loss or potential loss. So that, I think, neatly encapsulates the general rule, but also the principle in relation to mitigation costs. Once they're incurred, the insurer is in breach for failing to indemnify, and the limitation period starts at that point. So I mentioned the position in relation to liability insurance is slightly different. And the question to ask in relation to an insurer's obligation to pay damages under a liability policy is, when is an insurer in breach for failing to indemnify an insured in respect of that liability to pay a third-party damages? So the general rule, most of you will know, is that the limitation period under a liability policy commences as soon as the third party has established and quantified the insured's liability by means of a judgment, arbitration award, or binding settlement agreement. So the date of accrual for a claim for indemnity in respect of damages payable to a third party claimant is the date of judgment, award, or settlement. And if we compare that position with, say, a property policy, so a property policy where the date of breach will be the date of damage, and where the insurer is deemed to be in breach, even though the amount of damage will be unknown at the date of damage, so will almost always be the case, compared with, on the other hand, a third-party liability policy, where the date of breach is the date the liability is established and quantified, which could, of course, be, and will, of course, be many years after the insured has acted in breach of its obligations to the claimant. So, in relation to a liability policy, the limitation period is not postponed to the date on which the insured makes actual payment of the damages. It's the date liability is established and quantified. Now, that's the position in relation to a damages payment, but the date of accrual in respect of a claim on a policy for defence costs will be the date the defence costs were incurred, as per the principles we've just looked at in the Europools case. So the date of accrual in respect of defence costs will therefore almost always be earlier than the date of accrual in relation to a damages claim, as defence costs will obviously be incurred prior to settlement or judgment. And the obvious point here is that if a policyholder has settled a claim or had a judgment awarded against it, but is still in dispute with its liability insurer about its entitlement to indemnity, it should be mindful that the limitation period for claiming defence costs is likely to expire before the limitation period for claiming damages. So it's important to work out when those costs were incurred, and then work out the 6-year period when that expires. So one other issue arising out of liability policies is that there is inevitably going to be a considerable time gap between the date on which the insured notifies to the insurers the possibility of a claim against him and the final date on which the insured's liability is established and quantified. So in this period, the insurers might deny liability or act in a way which amounts to a repudiatory breach of contract. For example, by purporting to avoid the policy for breach by the insured of the duty to make a fair presentation. So another risk area here to be mindful of is that if the insurer acts in repudiatory breach in this way, for example, by purporting to avoid the policy, and the insured accepts the repudiation, thereby bringing the policy to an end, the cause of action accrues at the point of repudiation and not the point the insured's liability is established. So the pitfall there is if the insured accepts the repudiation, that will mean that the accrual date is earlier. If the insured does not accept the repudiation, the date of accrual is likely to be, as per the ordinary rules, the date the insured's liability is established. But that's just, like I say, another pitfall to be mindful of. So next slide. So I mentioned that parties can vary the limitation period. So it's a statutory limitation period which can be varied by agreement. And as I mentioned, the statutory limitation periods do not extinguish the claimant's cause of action, but merely provide the defendant with a defence. So the parties can contract out of the right to rely on a limitation period. They can agree to vary the length of the limitation period, or as I've mentioned, they can enter into a standstill agreement, which has the effect of stopping the clock for limitation periods, which I'll talk about in a second. Now, it's rare that a policy will vary the length of the limitation period, or that insurers will contract out in the policy of the right to rely on a limitation defence. So the most common situation where the limitation period will be varied in an insurance context is by virtue of a standstill agreement, which will be entered into post-loss, typically perhaps where the parties are involved in negotiation or mediation close to the expiry of a limitation period, because if you cannot get a concluded agreement in place with insurers, it will be necessary to issue protective proceedings, protective claim form, or arbitration notice. And as I say, the effect of a standstill agreement will typically be to stop the clock running for the purposes of limitation. And in terms of how else you might vary the limitation period, note that there is a particular position in relation to the late payment of insurance claims. So Section 13A of the Insurance Act introduced an implied term, which said that insurers basically must pay insurance claims within a reasonable time. It's a statutory right that every insured has. And on ordinary principles that I've discussed, one might expect that an insured bringing such a claim would have 6 years from the date of the insurer's breach of contract to bring its claim, i.e. 6 years from the date by the point when the insurer should have paid the claim. However, it's another pitfall. Claims for late payments are themselves subject to a special limitation period, and they must be brought within 1 year of the date on which the insurer pays the claim. That's Section 5A of the Limitation Act. So if you have settled any claims for insureds within the last 12 months, where the settlement doesn't compromise the right to bring claims for late payment damages, the time for bringing such claims will expire 12 months from the date the insurer made payment. So that is one to keep an eye on also. Okay, so I've talked about the point at which the cause of action will accrue generally, but it is possible for the language of the policy to mean that the general rule does not apply, i.e. the point at which the cause of action accrues is deferred. So at the risk of labouring the point, it's always important to look at the policy. And a particular difficulty in many of the decisions is that it can be difficult to determine whether policy terms relate to the insured event and therefore the date at which the cause of action accrues, or whether the terms merely relate to the insured having to prove and quantify its loss after the insured event has occurred. So what do I mean by this? Well, for example, generally, a claims condition which says the insured must provide evidence of the loss, but the insurer is liable to pay a claim, will not defer the point at which the cause of action accrues. So in the case of accident insurance, as I've mentioned, the general rule remains that the insured's action accrues on the date of the injury, even though no payment is due under the policy for a given period after the injury. Although, and this is the rub really, the policy may be framed in a manner which defines the insured event as the expiry of a given period following the occurrence of the injury, so that the limitation period starts to run only on expiry of that period. And that was precisely the position in the Verk and Gan Life case, where the Court of Appeal affirmed that principle. And the relevant parts of the policy are on the slides, but in essence, under the policy, the insurers agreed to pay the claimant a critical illness benefit if he suffered a stroke. And the claimant suffered a stroke on the 11th of August 1992. And if the claimant's cause of action arose on that date and the limitation period commenced to run from that date, the claim would have been out of time. However, it was determined that by the terms of the policy, the limitation period, in fact, ran at least from a date 30 days after the 11th of August 1992, in which event the action was commenced within the limitation period. And the key parts of the policy are underlined on the slide, but the insured, in essence, was able to successfully argue that the payment of the benefit sum under the policy was due when there was a confirmed diagnosis of his stroke, and if and when he survived for 30 days after such confirmed diagnosis. So the earliest date the limitation period started to run was 30 days after the confirmed diagnosis and not from the stroke. So if you think about that question in the context of when was the insurer in breach, it couldn't be in breach before the 30-day period expired because there was no payment due yet. So that is obviously an accident policy, but that principle has potential application to all other types of insurance policy as well. So it is also possible for an insurer to lose the right to rely upon a limitation period by virtue of the concept of waiver. And this will be the case if the 4 conditions on the slide are made out, namely, if there is a clear, unequivocal, unambiguous, and unconditional promise by the insurers that would not raise a limitation defence and that they were giving up that right. The promise was construed objectively, not capable of more than one explanation. The insurers had gone beyond simply negotiating with the insured about the claim, and there had been reliance on the promise by the insured before the limitation period expired in the form of altering its position in such a fashion so it would be inequitable for the insurers to plead their limitation defence. So you will, I hope, readily appreciate that it will be quite difficult in many cases for an insured to make out that all those requirements have been satisfied. And for example, mere silence by the insurer in the course of negotiations would not amount to a waiver, and there's nothing capable of being construed as an unequivocal statement. So if you're in negotiations with insurers and the limitation period is due to expire, because it may be difficult to make out the requirements of a waiver position after the event, it's clearly much better to try to agree a standstill agreement, or if need to be, issue protective proceedings. And this principle might be surprising to some, but there's a particular difficulty can arise where an insurer makes a partial payment in respect of a claim. That of itself will not amount to a waiver of the insurer's rights to subsequently rely on a limitation defence in respect of the balance of the claim. So that principle was confirmed recently in a Northern Ireland case, Ban Carraig, which followed English law principles. And in this case, the insured's premises were broken into and vandalised, and it claimed on its policy for property damage and business interruption losses. The property damage claim was paid in full, and insurers made a part payment of the business interruption claim. And as an insurance claim, it's a claim to recover unliquidated damages and not a claim to recover a debt. The right to rely on a limitation defence by making part payments is not lost. And that basically means that Section 29(5) of the Limitation Act doesn't apply. So from the insurer's point of view, they've had a partial payment in relation to the business interruption claim. The time for bringing that claim, for issuing proceedings, etc., has expired, and the fact the insurers have made part payments, did not amount to a waiver. So again, beware. The mere fact they've made a part payment doesn't mean they won't be able to rely on limitation. And just to add, actually, that this case also reaffirmed that the cause of action in respect of a business interruption claim accrues at the date of damage, when the business was first interrupted in consequence of the damage, and not some later date, even though the business interruption loss was ongoing and it continued over, the 12-month indemnity period. So it's quite an interesting little case. Excuse me. So I wanted to talk about COVID claims, and the reason for doing it will be obvious to many, but it's likely that there will be many COVID business interruption claims which have not been resolved or not paid in full by the time limitation periods start to expire. So for example, there's a court of appeal judgment in September 24 paved the way for thousands of insureds to recover at the premises, under at the premises wordings. There's appeals in January 2025 in relation to non-damage denial of access wordings and furlough payments. And if you're a betting man, you might think that many of these issues will not be resolved by the time limitation starts to expire. Now, I was thinking about giving you some specific pointers in relation to this, but I've concluded that because there are so many wordings out there, it would be dangerous for me to do so, and therefore I think the prudent thing for you all to do would be to look at the policies where you are likely to have unresolved claims, and determine for yourselves, based upon the policy wordings, when the cause of action will expire or first start to expire. And under most business interruption policies, there will be several points to establish before it can be said that the insured peril occurred. So the 6-year period will commence at the point all those ingredients have been satisfied. So things like when a typical insurance clause might say, could be the date that COVID becomes a notifiable disease, the date of government advice or action, or the date of the first lockdown order. And they all occurred generally in March 2020. However, as I say, it's not legal advice, and the date could be earlier based upon what the policies say. So, for example, insureds with the RSA 4 wordings in the FCA test case were able to recover losses from the 31st of January 2020, and that was because their policies covered interruption caused by a disease which subsequently became notifiable. So the fact that COVID was not notifiable as at 31st January was not deemed to be the trigger, and the trigger date of 31st January was based upon the date. That was the date when there was the first positive case of COVID in the UK. So it could be, it's generally going to be lots of periods will start to expire in March 2026. It could be earlier. There's at least some wordings that's the end of January. So to the extent you are dealing with unresolved claims, as I say, you need to establish when the cause of action accrues, when the limitation period expires, and seek to agree standstill agreements with insurers well in advance of the limitation periods, bearing in mind that it may take several months for to agree those agreements, which will obviously need to capture all relevant claims, and bearing in mind the potential for, well, if not mischief, but just genuine, legitimate areas for disagreement with insurers as to what those agreements should cover, you are going to be well advised to get on with that process well before the end of next year, I'd suggest, having established when limitation expires. And as I say, if you are unable to agree standstill agreements, then the correct course of action will be to issue protective claim forms or arbitration notices, again, which capture all relevant claims. So I'm just going to go on to, so this actually is my final slide, and I just wanted to talk about the Third Party Rights Against Insurers Act 2010. And as you will all know, the Act basically allows a claimant to bring a claim against a liability insurer directly where an insured has entered into insolvency and where the insured is insured under its policy in respect of its liability to the claimant. So the insured can bring proceedings against the insurer, sorry, not the insured, the claimants can bring proceedings against the insurer, both for a declaration as to the insured's liability, but also in respect of the insurer's liability under the policy. And to successfully recover from the insurer, a claimant would need to establish both that the insured is liable and that the insurer was liable under the policy in respect of the liability of the claimant. So there are two limitation periods to think about. The third party claimant's claim versus the insured. When does this become time barred? And that will, under ordinary rules, be 6 years from the date of accrual, which could be a different period in contract or in tort, or if later, 3 years from the date of knowledge. So that's the first period to think about. And secondly, the limitation period in respect of the third party's claim against the insurer. When does this become time barred? And based upon the principles we've already discussed in relation to liability periods, that period will expire six years from when the insured's liability to the claimant is established by judgment or settlement. So just unpicking some of this, the general position is that where a claimant seeks a declaration from an insurer as to an insurer's liability and the proceedings are brought after expiry of the limitation period for bringing the claim against the insurer will be able to rely on a limitation defence which was available to the insured in arguing that the claim against the insured is time barred. So in other words, if the insurer is faced with a claim, if the claim against the its insured is already time barred, then the insurer will have a defence, a complete defence. So you cannot be in a better position as against the insurer than you would have been as a claimant against the insured. So if, for example, you've brought a claim against a professional, say a contractor who has become insolvent, and you are now considering pursuing the contractor's PI insurers for a declaration as to the contractor's liability, you will need to issue proceedings against the insurer before the limitation period for claiming versus the contractor expires. So there's different limitation periods, but the earlier the one against underlying insured is the one really to establish up front, to diarise and to make sure that you meet. And then having done that, hopefully, where the claimant established the insured is liable by judgment or settlement, as I say, time begins to run for the purposes of claiming against the insurer at the point the liability is established. So hopefully that is all clear. I have reached the end of what I was going to talk about, but I'm just going to see if we've got any comments in the chat. So I've got a specific question about Liberty Appeal due to be heard in January 25. I think if that's from Sam Mitchell, I think, Sam, if you don't mind, I will take that offline, and we can pick that one up with you directly. I think that is it for questions. So, like I say, if you have anything else that you would like to discuss in relation to limitation, please let me know. My details are on the slide. I'll be happy to pick up with you. And otherwise, please let us know what you thought about the webinar. And we look forward to hearing from you again in the future.